Ladies and gentlemen, my name is Anthony W. Astafan. I'm the lead counsel in the matter involving Dr. Dennis Merchant. With me this morning also is one of the senior members of the team, Mr. Sylvester Anthony. We have a few things to speak about today. Dr. Merchant will say a few short words. I will then say a few words on a number of issues arising from the judgment, and then we'll be open to questions. So without much further ado, let me pass you on to Dr. Merchant, and when he's finished, I will say a few words, I will take questions.
Good morning, ladies and gentlemen. I'm indeed very relieved and happy by the decision that was made by the Court of Appeal earlier this week. The decision, in my view, is a clear vindication of the Office of the Attorney General. I am happy to say that there was no evidence to support any of the allegations that were mounted against the Attorney General. And we all are aware that the Attorney General, as well as the Office, was the target of much criticism, vilification, and castigation. One would hope that all of that can now be properly put to rest with the appropriate professional courtesies. It is my view as lawyers that we are expected to operate at a very high standard, and the profession can only benefit not only by eloquent speeches, but by doing what is professionally right and decent at all times. May I just take this opportunity in giving thanks to God above, but also, most importantly, thanking my legal team, which was headed by Anthony Astafan, SC, and also to thank my many supporters on the outside for their prayers and such like throughout this period of much difficulty during the course of awaiting this decision. Thank you very much.
Thank you, Dr. Merchant. I need to apologize for Dr. Henry Brown, who is also perhaps the next most senior member of the legal team, but he's presently engaged in the Court of Appeal and is unable to be with us now. He may try, but I doubt very much he'll be here by the time. Ladies and gentlemen, the judgment. The Honorable Prime Minister and myself, immediately following the judgment, demanded that Mr. Lindsey Grant, leader of the People's Action Movement, and Mr. Mark Brantley apologize to Dr. Dennis Merchant for what we thought were their partisan political calls for his immediate resignation. One of the things we have to bear in mind as to why we said that and why today I maintain the demand for the apology is that both Mr. Mark Brantley and Lindsey Grant are attorneys at law. They are fully aware of the fact that the due process under the rule of law and the supremacy of the Constitution gave Dr. Merchant a right of appeal, and that the judicial process does not end with a High Court judgment. And throughout from the time the judgment came to the filing of the notice of appeal, to the hearing of the appeal and after the appeal, they have maintained a position that we think falls short of the standard of persons expected to be political leaders who are also attorneys at law. The judgment has been a complete and unadulterated vindication of Dr. Dennis Merchant. That on itself demanded an apology. And the suggestion somehow from Mr. Grant that a judgment of the High Court was a sufficient basis for the demand really and truly is total and absolute nonsense, because Mr. Lindsey Grant was himself confronted with a videotape showing him in the act of committing a more serious act of misconduct, if not criminal act of misbehavior. And he never resigned. I don't remember him calling for his own resignation, or members of the People's Action Movement or Mr. Mark Brantley demanding the resignation of Mr. Lindsey Grant. And I find such hypocrisy difficult to swallow. Mr. Lindsey Grant may never be vindicated from that video recording of him at the Marriott, but Mr. Dr. Dennis Merchant has been completely and absolutely vindicated. The court held that there was absolutely no basis in fact or in law for the findings of contempt against Dr. Dennis Merchant. In fact, the Court of Appeal, and more specifically, Madam Justice of Appeal Olime Edwards, who was the most senior member of the court and who presided in the Court of Appeal, in her ruling made it clear, in her view, the injunction, which has become part of the political landscape of this country, expired when the Boundaries Commission submitted its report to His Excellency the Governor General. Her ladyship was of the view that on submission of that boundaries report to His Excellency the Governor General, the injunction expired, it died, it lapsed, it was redundant, it had no legal effect thereafter, and was incapable, following the submission of the report to His Excellency the Governor General, to have had any application to any of the provisions of the Constitution or any act which followed the submission of the report to His Excellency the Governor General. To be more specific, ladies and gentlemen, her ladyship and the court were of the view that the injunction did not extend to the Honorable Prime Minister Dr. Denzel Douglas, did not extend to the proceedings of the Parliament, and therefore there was no valid, living, extant, or enforceable order at the time the Honorable Dr. Denzel Douglas submitted the report to His Excellency the Governor General. The court was also of the view that the terms and language of the order were so vague and so impractical, imprecise, as on its face to make it a useless order insofar as the proceedings of the Parliament were concerned, that it had and could have had no application to the Honorable Prime Minister and the Parliament. The significance of this are twofold. Once the Honorable Mark Brantley walked out of the Parliament on the basis and on the allegation, now turns out to be totally false and unsubstantiated, that the government was violating the order of the court. That piece of political drama has now turned out to be an exercise in nonsense, an exercise in futility, based on a complete misreading, misunderstanding, and misinterpretation of the order of the court. The other implication is that the continuation of the allegations, more recently reflected in a release of the People's Action Movement, that the government violated the order of the court, is nonsense. It's constitutional, jurisprudential, and forensic nonsense, because there was no order in existence at the time the Honorable Prime Minister laid the report to the Parliament for any serious allegation, any bona fide allegation, any allegation worthy of nothing more but contempt, that in doing what he did, the Honorable Prime Minister committed an illegal act. So, in our view, the judgment of the court not only completely vindicated Dr. Dennis Merchant, but has and should and will, in the minds of those interested in the truth, put to mind the misinformation that the government, quote unquote, as Mr. Justice Michael Gordon said, whatever that means, violated the order of the judge.